Hi all, welcome to this meeting of the Nathanson Centre on Transnational Human Rights, Crime and Security, Legal Philosophy Between State and Transnationalism lecture series. Our speaker today needs no introduction, as he likes to say of every speaker he introduces in the series, but for different reasons than usual, because he's the man who owns this lecture series. But still, as he does for speakers who need no introduction, I'll be giving his introduction. François Tanguay-Renaud is an assistant professor at Osgoode Hall, but also, luckily for us, a member of the graduate faculty of York's Department of Philosophy, where I also teach. He is the associate director of the Nathanson Centre, which funds this seminar series, as well as the Osgoode representative on the Ontario Legal Philosophy Partnership. He studied law at McGill University, from which he holds degrees in both civil and common law. He also spent time at the National University of Singapore, where I presume he studied draconian law, and at the University of Oxford, where he held innumerable fellowships. He was a Rhodes Scholar, he was a holder of the studentship of the Centre for Ethics and Philosophy, and he had funding from the FQRSC in Quebec and SSHRC. François has clerked for the Supreme Court of Canada. He has worked for many NGOs in Asia, Europe, and North America, and he's been a visiting professor at the National Law School, University of India in Bangalore, as well as more recently, HLA Hart Visiting Fellow at Oxford University. His research focuses on criminal, constitutional, and international law theory and associated fields in moral and political philosophy. He's published in a number of distinguished journals, such as Legal Theory, Ethics, Res Publica, and this one, Criminal Law and Philosophy, coming out soon. He's the co-editor of the forthcoming collection, Rethinking Criminal Law Theory, New Canadian Perspectives in the Philosophy of Domestic, Transnational, and International Criminal Law, which is coming out in 2012. Today, François will talk to us about criminalizing the state.
Thank you very much, Louis-Philippe. It's really a pleasure to be here with you on the other side, in the hot seat today. It's fun to be sitting there because you can just grill the other person, but when you're there, you have to pretend like you have answers and that they are coherent. So I'm going to talk to you today about criminalizing the state. That's a paper that's part of a larger project which seeks to understand the state as a possible wrongdoer in both law and morality, which will turn into a book, hopefully in the coming years. So that tackles a part of this puzzle, a pretty provocative one, rather uncharted territory. For criminal law theorists, both of international and domestic law, perhaps more for domestic criminal law theorists, but in fact for both, when they turn their gaze towards the state, trying to understand what kind of entity it is, they tend to try to understand the state as an agent of criminal law. That is, they tend to try to understand the state as the entity that makes, that defines, that promulgates, that adjudicates, that enforces criminal law. And the working assumption is that by doing so, then we might be better able to understand what criminal law and criminal processes are and what they should be. It's interesting that, at least to me, that criminal law theorists have rarely pondered the question of whether we could also think of the state as an agent of crimes, whose conduct could itself be the subject of criminalization and could be dealt with according to a certain criminal process. Now, it's been almost half a century since Hannah Arendt asked for this inquiry to take place. She was sitting in front of the trials of Adolf Eichmann in Jerusalem and thought to herself that what this man had done, he could not have done alone, right? He could only have done this under a criminal state and under a criminal law. Now, a number of criminologists, that is not philosopher, criminologists, have heeded Arendt's call and have inquired into this question, the possibility of state crimes. Unfortunately, most of these discussions tend to be marred by conceptual confusion, right? What is state crimes? We don't even know what the state is. It refers to, yes, things that could be called state crimes, but also crimes that are committed by individuals who are more or less related to the state, or sometimes even power more generally in society, remarkably few analytical philosophers of domestic criminal law, but also international criminal law, have followed suit. Now, there are some who have gotten to the edge, but really the question has never been addressed up front. When I say not addressed up front, that's not to say that the issue doesn't have philosophical lineage. There are people, pretty famous people, like Immanuel Kant, like Thomas Hobbes, Dennis Thompson, Hans Kelsen, Joel Feinberg, who in passing have argued against it. And it seems that their claims have some purchase because their position has really become the orthodoxy, and a rather unquestioned orthodoxy. So in this paper, I'm trying to see whether this orthodoxy is really as incontrovertible as these greats seem to think. And so I proceed in the paper by trying to identify what I take to be the core objections to state criminalization. And by this I mean objections to criminalization as is broadly understood in theoretical circles as the public condemnation, censure, blame, after a certain process of calling to account, and then punishment of the state as a result of a suitably criminal process for the culpable or blameworthy perpetration of legal wrongs. And then in the paper, I go on and I investigate each of these objections and see how and whether they could be challenged, whether we can loosen the grip of the objections on the question. The first such objection I'm going to talk about is that some people tend to think, at least at the domestic level, that it's unintelligible to think of the state as a possible criminal, as some entity that could commit crimes. I developed here an account of the state as a real agent, almost a person, which I think in irreducible terms can sometimes commit both moral and legal wrong. I move on from there to question a set of objections to the intelligibility and legitimacy of subjecting states to the domestic criminal process. Objections that primarily find their root, their source in the fact that, at least in the domestic context, it's the state that is typically thought as the quintessential prosecutor, judge, and punisher. Again, I'm not sure how far these objections really take us. And from there, I carry on to address the distinct, yet I think related objection that at least in aspiring liberal jurisdictions, treating the state as a criminal really objectionably involves extending to it various guarantees, various rights, substantive and procedural, that given its nature, given its raison d'etre, it shouldn't have. And the last set of objections that I address have to do with the issue of state punishment per se. And here there are a number of objections such that the state, qua entity, is not something that can really suffer punishment. It's also the fact that it's also, it seems, an objection that there's a constant possibility that whenever the state is punished, there's a possibility that that punishment will be dispersed among the individual state members, and that this stands in the way of the justification of state criminality. And finally, I address the question of whatever justification there may be for making things harder for the state in response to its culpable wrongdoing. This kind of treatment need not be understood as punishment in and of itself. So you could say the focus of the discussion is on domestic state criminalization and its possibility and possible legitimacy, but peripherally also deals with the question of international state criminality. I take the objections to domestic state criminality to be objections that also apply at the international level and to be stronger, as it were, at the domestic level. So I focus on that case. I conclude the piece. If I have time, I'll talk about this by contrasting different alternatives that there could be to state criminalization. But in the last analysis, I contend that what I will say today and what's in the paper leaves us with enough to keep the possibility of state criminalization on the table as a justifiable response to state wrongdoing, even if doing so compels us to rethink certain aspects of criminalization, of what's required for the justified criminalization of individuals. Now, you may think, is this just an abstract project? François, why are you thinking about this? States are not criminal. Well, are not criminals, or they're at least not criminalized. Are you just making a kind of de lege ferenda argument, or are you just hypothesizing something that could be but that will never be? Well, if you look at legal systems the way they are shaped, you have at least embryonic ways in which that question is present, right? So if you look, for example, at the Canadian Criminal Code, the Criminal Code of New York, the Criminal Code of Indiana, you see that core state organs are sometimes singled out as entities that can be subject to criminal prosecutions, at least on the book, right? They're typically not prosecuted. Historically in the US, they sometimes were. But here I'm talking of governmental or governmental instrumentalities, governmental entities, public bodies, public agencies. So that's one way. You might say, well, that's not quite the state, right? It's just some entities within the state. But what about constitutional law, right? We don't tend to think of constitutional law in criminal terms, but it's the fact that in countries that have bills of rights or charters of rights, well, the state is regularly condemned judicially for infringements of rights, and sometimes even judicially punished, right? So that's not often the case, but in Canada, for example, under Section 24(1) of the Canadian Charter of Rights and Freedoms, punitive damages are sometimes deemed an appropriate and just remedy for egregious violations of constitutional rights that result from state action. Now, in international law circles, if you are familiar with the discussions of the International Law Commission, you'd see that at some point in the development of their articles on state responsibility, there was a category there in the drafts. International crimes of states. And these crimes referred to things like aggression, like mass pollution, slavery, genocide, apartheid. Now, the category was dropped along the way, but in current regimes of international individual criminal responsibility, state, perhaps criminal behavior seems to, at least that idea seems to hover in the background. For example, the Rome Statute makes it the case that individual crimes against humanity have to be perpetrated pursuant to or in furtherance of a state or organizational policy. So the idea of state criminalization seems to have at least some purchase in the law, and I hope that the kind of inquiry I'm engaged in today will assist thinking about these various categories. And it bears repeating, I think, initially, that the focus of my article is not on crimes that state officials may commit in their personal capacities. Now, there are crimes that some individuals can only commit by virtue of the fact that they're occupying certain roles in the architecture of the state, right? If we're here, for example, we have certain corruption offenses that are involving the disclosure of information that's obtained in the course of state employment. Offenses of desertion, for example. But these remain individual crimes. My focus here is on the possibility, which is a more provocative possibility, of crimes by the state itself. So the first objection I said I would address is and that's perhaps the objection that's the most complex to address in a seminar like this, because in the paper I deal with it building on other works that I've done, and on the work of other people who have written countless articles and books about the issue. And there's some people from my class in the Philosophical Foundations of Criminal Law here, and we'll have discussed the possibility of the state, or at least some organized groups of individuals constituting agents, right? Agents that are both moral agents and can therefore be also agents within the law. And here I'm referring to, and I'm using the work of Christian List and Philip Pettit to make my case, which I think is the most sophisticated work on group agency, real agency, that is out there. It's recent work, but quite thought-provoking. And the basic idea seems to be that there are some organized groups, which I'll call corporate organizations, that are fit to be held responsible, blame, condemn, censure in the same way as individuals, wrongdoers. They're fit to be held responsible and blamed for wrongdoing, including criminal wrongdoing, which they, as agents, planned, or programs. Seems to me that the operative thought is that we can think of the modern state, or at least certain modern states, as conversible agents, right? They are entities with which it's possible to enter treaties, right, for example. And when we enter treaties with a state, well, we can expect that the state will live up to the treaties. It's possible to do business with that agent through language. Now, you may say the state is not something that is distinct from the individuals that constitute it. Everything that goes into the state goes into the state via individuals, and everything that comes out, any action that the state brings about into the world is also done by individuals. Petit and List accept this. So if we're going to have or talk of the state as an agent, which is different, irreducible to its constitutive individual members, there needs to be something more, as it were. They need to be independently fit to be held responsible for their own wrongdoing. And so, in a sense, be irreducible in a salient way to their individuals, in a way that allows us to hold them responsible for what they do. And so Petit and List say, well, the operative feature here is that certain groups of interacting human beings can be relatively autonomous agents. That is, they can form beliefs, judgments, action-directing attitudes, as well as action plans that cannot be reduced fully to those of their members, thanks at least in part to the operation of a normative framework or constitution, which is adequate for that purpose. And they say, well, the Constitution is adequate when the organized group's judgments or attitudes are, on the whole, functionally independent, as opposed to a mere reflection of the corresponding judgments and attitudes of the individual members. So as a general rule, for example, and we can go into this more in discussion, but that's a metaphysical question I don't want to engage directly in my talk. As a general rule, as well, simple procedures, for example, such as majoritarianism, don't suffice, right? It cannot be a direct function of what individual thought, otherwise it's the same thing. There also needs to be some sort of process in place to ensure that the group can correct its irreducible judgments and attitudes over time, so as to enable the group to exhibit over time the kind of minimal rational consistency that we expect of agents proper. And the idea is by jointly committing, adhering to this kind of constitution, an organization's members can generate a single corporate agent which, when it's faced with significant normative choices, is capable of making judgments, irreducible judgments about what's good, what's bad, right, and wrong. Right? It acts upon the data that individuals throw, as it were, in the black box of the state. But what comes out is, by virtue of the Constitution, is not necessarily reducible, at least over the course of time, to what the state does. And it's better described as being the state that's acting, and that's not so much acting as coming up with certain attitudes, let's call them cognitive at this point, such as intentions, which allows it to plan for actions. And then the state, through this process, may control for the performance of these actions by arranging for things so that some individuals are directed or empowered to perform the relevant tasks, while other people, for example, are appointed as backups, right, to fill in if the appointed individuals don't do it. So List and Petit tells us the state can be the source of certain deeds, right? There can be a multi-level causation at play here, where the state is the source of the deed of certain individuals, or at least partially so. Now, of course, the individuals who give life to the state, right, put things in the state and execute the decisions or intentions or plans of the state, also responsible or possibly responsible on their own for what they do in their own right. But it's also the case, it seems to me, that the entity that they maintain, or so and List and Petit argue, also has to answer as a whole for what it does at the corporate level, while making use of the resources of of its members. And it seems to me that the state is a good example of an organized group that might meet this kind of model, right? So modern states have constitutions that typically include goals and principles of governance, multi-layered decision-making procedures. They impose the kinds of balances and checks that are necessary to foster relative organizational autonomy and sufficient rational consistency over time. Think of all sorts of constraints that we're familiar with, right? The separation of powers between the executive, the legislative, the judiciary, bicameral legislatures, federal divisions of power, judicial review of administrative and legislative action, stare decisis, elections, conventions of ministerial and cabinet responsibility, impeachment procedures, and the like. Of course, states depend on their individual members to make decisions and act, but by committing and adhering to the constitutional framework to a reasonable extent, then they enable their state to act as an irreducible agent. And when I say irreducible, I don't mean in a metaphysical way, I mean in terms of the proposition that the state brings forward, as it were. Now, you might have realized by now that I talk about the state as a whole. Our government or another administrative agency of the state might also meet the conditions of corporate irreducible agency. And when that's the case, well, you might have different agents at play, and these subsidiary group agents might play a role in inputting information into the state and in executing the decisions. It's sometimes, think of the debt crisis in the US, it might be that the state decision, the overall compromise of what comes out of the decisional process is not the same as what the government, the executive, would want. So that's just a point that I make in passing so that so as to be clear and avoid confusions. Now, you say, well, is it intelligible for this kind of agent to commit wrongdoing? Well, it seems to me that it is, just like it is for you and I. Is it possible for the state to commit legal wrongdoing? Well, Thomas Hobbes says the state is the law. Well, the state may be constituted by partly law, as the norms of the Constitution, but first of all, it's not just law, right? There are all sorts of socio-political considerations at stake. A state needs to be recognized by people to exist and perform as a state. It's also the case that there are all sorts of social norms, political social conventions that go into constituting the state, which may allow it to act in extra-legal ways. And we can talk a bit more about this in the discussion. So I just wanted to put this model on the table because I think it allows me to deal rather efficiently with the first objection. We can talk about the nitty-gritties of how later on. Now, I'm not denying that states, as well as their subsidiary corporate agents, can fail to meet the conditions of irreducible agency. In fact, many states may, either because of constitutional deficiencies or because people lack commitment to the Constitution. And it may be that in such case, legal fictions of state criminality might still be invoked. And now the question then becomes whether these fictions are justified. And in some scenarios, they might be. For example, situations in which fictions of state criminality would express, let's say, valuable denunciation of harmful structural deficiencies in the state, would express or would spur meaningful organizational reforms, or would provide optimal deterrence against future official misconduct, yet have virtually no side effects. But I think that fictional criminalization, just like it is at the domestic level with respect to individuals, vicarious responsibility and things like this, remains at best a non-standard case of the practice, which at its core is directed towards wrongdoing agents. So I stick to the paradigm of real agency, acknowledging that it might just be part of the puzzle, right? And that other models, ways of understanding the state may overlap with it and complement it at time. Okay, so that's what I wanted to say about the nature of the state and its ability to operate perhaps in a sphere of obligation amidst norms, qua agents, that is not to be equated, yet depends on the interventions of its individual members. Now you may think, well, how does it work? What if people don't recognize the state doesn't have any life, does not have any blood. That's the case, right? We need a minimum of recognition and acquiescence from the bulk of the population if the state is going to not to disintegrate into anarchy or fail to rise from it. And in fact, I think many theorists plausibly think that it's the mark of the modern state that it claims supreme authority, it claims sovereignty to regulate people's lives within its territory. So for the state to exist, the argument will often go on. That claim has to be sufficiently successful de facto. And one prominent articulation of that claim is that of Max Weber, who says that, more specifically, that it's a mark of the state that it successfully claims monopoly over the legitimate use of physical force within a territory. And traces of that kind of understanding can be found in Kant and Hobbes also, who think that, for example, punishment is something that's inherently an act of sovereignty. Right. Now, let's move on to the second objection. The criminal process is often theorized as a process in which criminal wrongdoers are called to account for their deeds. And so far as that view is correct, the question is, doesn't that pose a state challenge, right, for the possibility of criminalizing the state? That is, if the state is the kind of sovereign or supreme regulative authority that at least in principle may have the last word on everything within a territory, or at least successfully presents itself as such, who is to call it to account? Now, I don't think that challenge is conceptual. It's possible for somebody to hold themselves to account, just as it's possible for the state to do so. The real problem seems to me is at the level of legitimacy or of justice or appearance of justice that's associated with the state being judged in its own cause. The idea is, well, wouldn't a process by which the state calls itself to account be a process which is rife necessarily with conflicts of interest and will be necessarily biased? Well, here you could say international state bodies, in theory at least, could be sufficiently well designed and insulated to be able to call states, or at least many of them, to account by prosecuting and judging them justly, or at least with appearance of justice. That's one line of argument. It certainly has merit. But note that this idea of organizational independence, this idea on which it rests, can also be found at the domestic level. Right, the level of prosecution, you could think of private prosecutions, that are undertaken by victims, for example, perhaps with amicus curiae assistance from the system, and federal states prosecutors from one unit of the government that's not directly involved with the wrongdoing, supporting the prosecution. At the adjudicative level, you could also think of independence being fostered through guarantees of tenure, remuneration of the judiciary, discerning methods of judicial appointment, kind of stringent oaths of office, the kind of stories that we always hear about courts being independent and having to be independent. And constitutions tend to include bodies like this, courts, that occupy a special role in its architecture, an insulated role, as it were, in part to allow them to hold the state in check. So we generally don't have a problem with judgments by court about the legal validity of state action in constitutional administrative law contexts, for example. So the question becomes, why would a court that's sitting in judgment of the state in the criminal context be any different? You may say, well, constitutional context, administrative law context, that's the court dealing with legal validity. The courts are organizations that are mandated to apply the law, so that's part of their remit, right? But if the state can violate the law, in a sense, can commit wrongs, criminal wrongs, doesn't that amount to the state acting extra-legally in a way that would require the courts to recognize non-legal instantiations of the state and then to exceed their jurisdictions of being bodies that apply the law? Well, I think that's a pretty microscopic way or two reductive ways of understanding the plight of courts. Judges have oaths of office in which, yes, they agree to apply the law. That's essential to the rule of law. But they also take an oath to do justice, right? And in many jurisdictions, judges have found ways to address state legal wrongdoing that's perpetrated through legally invalid action in the name of justice, right? So consider, for example, the many judicial doctrines that have been developed to compel states to make good on all sorts of legitimate expectation that their legally invalid actions create amongst those who reasonably rely on them. Think also of the numerous cases in which courts depart pretty sharply from their legally circumscribed jurisdiction to affirm the continuity of states in the face of, for example, revolutions, or to give effect to previously non-legal constitutional conventions. I'm not denying that the courts have an important role in applying the law, but it may be that in order to uphold the rule of law and hold the state to account for its illegality, sometimes courts need to step out and recognize its extra-legal and violations of the law, as it were. Now you may say, well, that kind of inherent bias objection doesn't just apply to the adjudicative context and the prosecutorial level. What about the fact that states are the prime legislators of criminal law? Doesn't that allow them, at least at the domestic level, to simply move out and move out of jeopardy and legislate themselves out? Isn't that a strong objection? Well, here I'd start by saying, well, we shouldn't perhaps disregard fully the possibility that the state may hold itself to account. Enlightened states choosing to bind themselves anticipatorily through criminal legislation and subject themselves to the consequences. I mean, much of international law rests, perhaps outside Jus Cogens, let's say, on a model of voluntary state submission. And many defenses of criminal punishments rest on the idea of the criminal ideally assenting to, or if not willing, his own punishment. Still, you may say states may not be so upstanding and they may be tempted to manipulate legislation in their favor. And here I'm thinking, well, one way around this is to say, well, of course you could entrench crimes in constitutions, and constitutions are harder to amend. Another possibility may be at the international level to create systems in which crimes can be entrenched in treaties that states cannot move out of as easily as they may otherwise. So it seems to me that at least theoretically that's a possibility. Now, going back to domestic courts and accountability for a moment, you may say, well, they sometimes will be involved in the wrongdoing themselves, right? You might also understand the courts as being part of the state, right? So the executive, the legislative enacts a law that grossly violates the human rights of some individuals. The executive enforces it. The courts stay silent. A majority of the population endorses this. The courts are part of the wrongdoing. So how can we hold the state accountable? Again, perhaps at the international level, but insofar as we don't have international institutions that do it, what about the individuals themselves, the victims? Well, it seems to me that that might be a possibility that's worth exploring too. I won't go too much into this at this point because obviously it's a heavy question and you have the discussion in the paper. But you might say, well, there's two ways in which that might happen, right? The state, even if it has the kind of sovereignty that we think it has, may decide to like for example, in the German Grundgesetz, the Constitution, enact a provision by which individuals can resist it, right? Can do things to it if it does things that are egregiously wrong. It can permit this to individuals. And sometimes the authority of the state may simply not be legitimate. And when it's not, why think that individuals should just stay back? They might be the only ones that can bring about justice and make the state account for the wrongdoing that it does. So how much time? Like a few minutes? 10 minutes. 10 minutes, okay. So that's a possibility that I think should not be discarded too quickly. So there are many actors that we ought to think in this equation. Now you may think, well, isn't that a problem in many cases, right? Individuals might simply go overboard and they may do things that will impact the state too much in relation to its wrongdoing. And when that's the case, well, the state fulfills normally certain important functions. That might affect other innocent individuals in ways that is reprehensible. And so So the people who tend to advocate the possibility of individual resort to force in relation to, in response to state wrongdoing, tend to say, well, that needs to take place only in the most severe, crucial, and weighty cases, right? And so the Human Rights Declaration, the Universal Declaration of Human Rights in its preamble states, that the right of rebellion, which could potentially be conceived as a means or an avenue for state punishment, that right is a last resort. And these individuals who tend to acknowledge that it might be possible sometimes for individuals to step up to the plate and punish the state for criminal wrongdoing, that it should really be more discerning processes, judicial processes, domestic or international, that play that role, because these processes can be more discerning in what they do. The flip side is a lot of people say, well, in the context of courts, what courts, or at least in the context of the criminal process, tend to enforce a bunch of guarantees, right? Guarantees, rights that we tend to think to be quintessential to the criminal process, which the state, because of the kind of agent that it is, should not be entitled to avail itself of. Why might this be the case? I said, well, the state may be an agent, but that doesn't mean that it's an agent that is intrinsically valuable, that has moral worth in and of itself, that we ought to protect, right? The principle of value individualism, which I think is rather appealing and quite accepted in a widespread way, that principle stipulates that whatever has value, well, that value is to be derived from its worth to the life of individuals, or at least sentient beings, if we don't want to be too anthropocentric. And so states, as it were, qua irreducible agents, may not have the kind of value that justifies many of the protections and rights that are found in our criminal justice system. Now, the point that I make in the paper is to say, well, a lot of protections it might be true that justifications or excuses that are grounded in state self-interest, that should not be ascribed to the state. The state can be put in prison. That goes without saying. It may be that the protections against the state being retried should not be applied to it, but not all rights are justified in non-instrumental ways in such deontological terms, right? There might be non-instrumental justification for the procedural guarantees and rights in the criminal justice system, right? Such as the pursuit of truth. We want to know, we want to discern who are the actual wrongdoers and who are not. And so it seems to me that a lot of the protections that we have in the criminal justice system can at least in part be justified in these terms. And to that extent, I think that's rather comforting, is that we could have a process to hold the state to account which has some instrumentally justified guarantees that allows to hone in on wrongdoing without necessarily having to extend all of the guarantees that we do normally because of different justifications, yet some that are important and that we don't necessarily have an insuperable obstacle here. Now you might say there might still be situations where these rules can be overridden, when it matters that the state be punished so much that, consequentially it's justified to just move beyond these rules and discount them, possibly. It might also be that there are certain de minimis cases of state harm that we should simply not care about. But I think we're still in the realm of a plausible criminal process here. The last point, which I'm not going to discuss at length, is to say, well, can the state be punished? Can the state suffer? I said, well, the state, as I understand it, as this organized group, to the extent that it has certain characteristics, a decision-making procedure, it has a procedure to correct its own decisions, we can say, well, it can have some cognitive abilities. It can have some even cognitive abilities, action-directing attitudes. But it can't have emotion, can it? It can't suffer, right? So all the schools of thought about the justification of punishment that say that punishment is justified because it gives the wrongdoers what they deserve. That is, it makes them suffer to the extent that they deserve. It seems to me that in the context of the state, we need to move past that. But punishment, conceptually, is really just the imposition of a deprivation, of a loss, a setback in interest to people. or to agents for culpable wrongdoing that they do, or for at least supposed wrongdoing. And it could be justified otherwise, consequentially, right? It could be that in order to achieve a certain objectives, it's worth imposing certain forms of hard treatment on the state. Now you may say, what does it mean to punish the state as opposed to punishing its individuals? I'm not concerned with simply punishing agents of the state, right? I don't want to talk about the punishment of individuals. I want to talk about punishments of the state itself. And I said, well, there's something that's irreducibly the state's own, right? That's its irreducible beliefs, judgments, and action plans. And to the extent that the punishment is targeted to that could be spoken of in terms of state punishment. And you may say, well, even these targeted forms of punishment, right, could have impact on individuals, and some of these individuals may not have contributed to the state wrongdoing. They may not have been part of those people who voluntarily associate with the state. They may not have caused the state wrongdoing in any way. So should we permit this kind of punishment that extends consequences to state members that have nothing to do with the state? I think that there are certain forms of justifications here that may be applicable. The state, renders service to its population by taking certain decisions that individuals are not very good at taking for themselves. To the extent that the state does this legitimately, more often than not, when it really messes up and makes inexcusable mistakes, then it may be that it should not be holding the punishment centrally. It might not be fair not to allow for certain dissemination of punishment. But again, that kind of justification would be limited to a certain realm of statehood, right? The kind of states that are generally legitimate based on this service conception of state legitimacy. So we shouldn't discount that too quickly. You may say, well, isn't the case that most punishments will target individuals, right? Somehow, that you will have a focus on individuals, not just on the state, like punishing the state, for example, through war, through rebellion. Does that imply that we're not just punishing the state, but also we're going after individuals? That might be the case, and that might make these forms of punishment too indiscriminate to be ever justified. But there are other forms of hard treatment of the state's attitudes that might be justified, right? Think of civil disobedience that targets, policy, a certain realm of policies, injunctions for the state to modify, court injunctions for the state to modify its attitudes, plans, and policies. Well-tailored embargoes internationally, you could think of. Exclusion of states from international organizations, which may not have the kinds of heavy detrimental side effects on an individual that would render the punishment unjustified. So it seems that these objections, at least there are routes to address them, right? The paper is mostly a provocation, and you may say, well, why talk about all these things in terms of punishment, criminal punishment? And I say in the paper, because it matters. Of course, you could do all sorts of things to states to prevent it to do harm when there's no wrongdoing involved. But when there's culpable wrongdoing involved, it matters that we respond to the state through this idea of punishment, because punishment, criminal punishment in our society has meaning, right? It has an expressive value, and that is the kind of response that we tend to apply to this kind of behavior, right? So there's an expressive value that asks us to think seriously about the possibility of state punishment as something that might contribute to bring the state in line with either morality and law. Of course, you may say, well, this is all well and good, but aren't there so many other questions? And there are, The state is the kind of entity that, by its very function, tries to achieve certain goals via coercion, and we tend to think that's justified. So could the state have different kinds of justifications than individuals? What would be state criminality in and of itself? What kind of processes, both domestically and internationally, should we really devise were we to hold the state criminally accountable? These are really hard questions, and I don't seek to answer them in the paper. But it seems to me that we don't have the kind of mechanisms out there right now that really send the kind of message that criminal punishment and criminal accountability might lead to. The public inquiries, amnesties, tort law, all of this, they're not framed in terms of public condemnation and punishment the way that criminal law is. And just punishing the individuals within the structure of the state is also not enough. Why is it not enough? Because the grounds of responsibility for state wrongdoing and individual wrongdoings, because they're possibly different agents, might simply be different. It might also be the case that the individuals, because of their role in the structure of the state, lack relevant knowledge, or they're scared given their position, and so have excuses that the state doesn't have. So to prevent this kind of shortfall of responsibility, state criminality, I think, needs to be left on the table. Now, whether politics is ever going to allow this to take shape, that's another story altogether. I don't know. It might very well be the case that no. However, since the World Wars, this idea has recurred. Right? At the time of the Nuremberg trial, people were talking about state criminality. I've given you examples of when it takes shape embryonically in various legal systems. Whenever there's this kind of organized, heavy wrongdoing, right, or like organized torture that seems to emanate from a state, or acts of aggression, we tend to think we tend to hear calls out there for accountability of the institution and not just of individuals. So I don't know if it's ever going to take place, but to the extent that we already have something on the table, well, and that it's at least a theoretical possibility, then I think we at least ought to try to get the theory right. So there's a lot on the table right now, and I welcome all sorts of questions and criticisms that you might have so we can have a productive discussion and start thinking about this topic of state criminality, which is simply not addressed in the theory otherwise. Thank you.
Well, thank you, François, for a very stimulating and rich paper, and indeed I think we have a lot to talk about.
A lot.
Since we don't have a commentator today, maybe I'll start with just a clarificatory question.
And let's make sure we have the microphone.
Yes, and then we'll pass the mic around for other questions. But I wanted to ask you a little bit more about the conceptual framework, since in some ways the central question is really a conceptual question, which is when people who are state officials act in certain ways, should we say that they're criminals or that the state is committing a crime? Now, I think what you want to say about that may depend on how you think about the difference between justice and legitimacy. So here's one thought. You may think that justice is an ideal that the state should try to live up to, but it's a very demanding ideal, and the state falls short of it all the time in all sorts of ways. And when the state falls short of it, then citizens have a legitimate complaint. And you may think that legitimacy is a much lower bar that most states, or at least a lot of states, meet. You know, presumably the Canadian state is a legitimate state. And when a state fails to be legitimate in an action, then the implications are much graver than if it's unjust, because it just doesn't just give citizens a justified complaint, but it may give them the right to resist the state. And a thought that's attractive here is to think that's because when a state is illegitimate, then it's not really a state anymore. When the officials are acting illegitimately, it means they're not really acting as officials of the state. They're now a junta. They're people who are just, they're just a private association kicking other people around. Now, the reason why I think this might be relevant to the way you set things up is you talk about the possibility of popular state punishment. And usually we think if punishment is justified after the fact, then intervention would have been justified at the moment when the crime was being committed. Now that seems to me to suggest that at the moment when the crime is being committed, resisting the state is justified, which means it's illegitimate, which means it's not the state.
Right.
So presumably we disagree on how to understand one of these concepts.
Right. There's a lot on the table again, but that my paper makes that possible. So there's
I didn't invent anything.
There are many questions in what you ask. With respect to justice, I don't talk much in the paper as to what I deem to be state crimes. Right? One thing you might think is that, well, there are certain things that are injustices in the hands of the state that are not crimes. So the state in the society distributes wealth, but does it badly. It's unjust. Is it a crime? Now the state commits act of terrorism. Well, we tend to think, well, that's more in the realm of criminality. Right? So there seems to be work to be done in differentiating what's the realm of justice and what's the realm of criminality on one side. Now you say, well, let's look the other way. Let's think about justice and legitimacy. So I tend to think of legitimacy in a piecemeal way. So I don't think of the Canadian state as a state that is legitimate across the board. Right? I tend to be instrumentalist about this. I tend to follow, and I do in the piece, the work of Joseph Raz here, who says that an authority, or a claimed authority, is legitimate when, by following its directives, we are more likely to abide by the reasons that apply to us than were we to try to do it according to our own lines. So when the state, as I spoke about in the talk, renders us a service, is better than us, better placed than us to guide us how to act, then its authority is legitimate. Now you may say, well, if the state is acting illegitimately, then in a specific instance, because that doesn't require me to say it's always illegitimate. If it's acting illegitimately in a specific instance, then we may not have, as you say, the duty to abide by it. That doesn't mean that it's not a state conceptually overall, right? For me, the structure is still in place. The kinds of framework is still at play. People are still evolving within it, but that given decision is not authoritative in a specific way. To that extent, can the individual oppose the state? Or you might say, well, they might have a duty to create an institution that can, if they can create an institution that will, hold the state to account better than the state will account itself, then they should do this. If they can't, then it may be, or if it's impossible, then it may be that they are the only ones who are in a position to deal with what's happening, right? What the state is doing, and to respond to it. And in that situation, it seems to me, well, it may be that they are in a position to punish the state. Now, the question of whether it's the state or not, so this fellow, for example, Arthur Ripstein, who talks about a Kantian understanding of the state, tends to follow the picture that you have, to say that legitimacy is actually a much more universal concept, right?
But I'm not sure that makes a difference, right? So let's take the Raz view of legitimacy.
Yeah, right.
So there's always a question: is the state legitimate with respect to a specific person at a specific time?
Right.
Then isn't there still pressure to say when the state is committing a crime against a certain person, the state doesn't have authority with respect to that person. It's not legitimate with respect to that person. And then the pressure is to say, with respect to that person at that moment, it's not a state. It's just some private individuals.
Oh, but that's
using the state apparatus for their private.
Yeah, but the thing is, if the conditions of corporate agency that Pettit and List lay out are accurate, and it's possible to have irreducible state agency, and the plans and the intentions that are put into action by an individual are not reducible to any individual, then for me that's still the state. It's not the state acting in an ideal way, far from there, but it's still the state.
Okay, I see. Thank you. So let's open the floor, and we should circulate.
Can I just follow up on
Yeah.
that? So I'm just wondering, I mean, that sounds like the right line to push, the one you were saying at the end.
Right.
But then when exactly do the crimes occur? Is it the dropping of the bombs, or is it the making of the decision to drop the bombs, or is it the putting in place of the structures that enable the bombs criminally to be dropped?
So that's an interesting question. So in criminal law, in individual criminal law, I'll call it like this, we have different kinds of wrongs, right? We have fully realized wrongs, we have attempted wrongs, and then we have a series of even more precocious wrongs, such as incitement or conspiracy, as in Kuwait is going through. You could say, well, maybe there are even thought crimes, right? I think the same analogy could be used with respect to the state, right? The question is then, when is it legitimate to criminalize that with respect to the state, these forms of early decision making? It seems to me, well, there might be less constraint than there are with respect to individuals, because they're not, again, valuable in the same way that individuals are. They're just corporations, and that analysis also applies to private corporations in the same way. Of course, there's always the question of side effects of what we do to the state on individuals that needs to be factored into the analysis. But it seems to me that there's not a distinct problem here. We have the question of inchoate anticipatory wrongs and how far they can be justified in the context of a liberal society. And that's, it seems to me, is a question that can be answered with respect to the state and perhaps even with more flexibility. Just a thought, but yes.
All right. Should pass the mic down.
There's the mic here, actually.
Oh, there is. Oh. Pass my other microphone.
Thank you very much for your, is this on? Yeah. Thank you very much for your talk, Francois. When we think about ordinary crimes in a domestic criminal system, there's not usually any statute of limitations on prosecuting them. You know, you can still be held accountable for a crime that was committed 40 years ago.
Yeah.
But when you're talking about a state, governments exit, you know, demographics change. The state, as we understand it, could be very different from what it was
Right.
when, you know, a particular instance of criminality was committed. So is it possible for a state to evolve past the point to say it's not even the same agent that we can criminalize, or what would you have to say about that?
That's an interesting point, and there are many issues wrapped up in this, right? So there's a question of, well, the state qua agent obviously persists over time. Otherwise, we wouldn't think of it as an agent that can be responsible. It could be agent in this moment, but it's not a responsible agent. It's not a conversible agent. So for this analysis to work, it needs to be that we have states that evolve through time. What holds them together? Some people say is the law. I tried to suggest in the paper that that doesn't quite work because the law is constantly violated. So what really unifies the state is, you know, the fact that there's this unified group of individuals or ongoing group of individuals, let's call it the people, the nation, that recognize this body as being, or perhaps international actors also recognize this body as being a state. Right? And you see this in international law too when you talk about the question of succession of states. Right? The states perdures, but there might be a point, a revolution, for example, where the identity of the agent changes. Right? The structures change, people think of the state differently. And so do the obligations apply in that situation? Then you might say, well, there might be reasons of justice to do so, to impose burdens on the new agent as opposed to the previous agent. But the real question I think you're asking is that, well, what if the justification of the state is not so much retributive, right, because it's hard to make sense of that, but it's mostly consequential. What if the state has changed in a way that would make any intervention in response to prior state wrongdoing irrelevant, right? The state has already modified itself in a way that it's good. There's always this question of expressive value that looms in the background. Some people may want states to own up to the past, right? We want Canada to say it was wrong what we did to the natives, right? And when the Australian Prime Minister comes up and does this and says, I apologize, when Harper says, I apologize, we say, well, you know, that's appropriate, right? So it seems to me that, and that's a case in which Canada has not, you know, resolved the issue. There's still a problem there, but at least we see the ongoing question being, and then there's all sorts of questions. You might say, well, over time, you know, the people who are in the state right now benefited from what happened then. The state as it is right now benefited from what happened then. So it's really, you know, even if it's reformed itself, there's still an acknowledgement that's needed, right? And there might be important responses to be had. So the question of states over time is an important one. I think for this analysis, I need to have the concept of an agent that evolves over time. I haven't turned my mind to the question of statute of limitation or all the complexities that go with that kind of question. But I don't think you present it as such, but an objection to the analysis, more than how do you flesh it out, right? So in an ongoing, and in the next paper, I could say, well, you know, that's a question that needs to be addressed. When is it the same state, and until when can the state be punished such that it's justified? Yeah. Okay.
Thanks, Francois, for a really interesting presentation. I missed the very beginning, so my question may expose me for having missed something that was there. It seems to me like you're grappling quite extensively with this conceptual question of what is the state? Right. Is the state more than the sum total of the institutions and the individuals? And I would argue other things like the symbols, the values, and right. so on that constitute it. In Canada, for example, the Charter as a document, but also as an embodiment of ideas, has been described as something to which all Canadians can identify. It's a binding agent. It generates social cohesion. I think there's a place for some of this constitutional theory that has an interplay with what you're saying, yeah. because with that buy-in, which is, I think the state is engaged in a constant process of negotiating its social contract with the people. With that buy-in comes potentially responsibility, and I think that's what you're arguing for. But I think you're making a far cleaner and easier argument, which is simply based on a normative position. I take it that we ought to expand the scope of criminal responsibility. I take it, given the levels of impunity that exist at least in international crimes. So you believe that the scope of punishment and responsibility needs to be expanded, and you want to apply what sounds to me like vicarious liability on the state for wrongs committed by the various constitutive agents and institutions that comprise the state. In a way, it's a very utilitarian argument that seems to fit within your approach to the state, which is not that it represents the collective aspirations of the people and therefore needs to be accountable, but rather that it's a vehicle. And if it's a vehicle, we perhaps will impute responsibility in circumstances that it's warranted in. And we do this in other contexts at the domestic level. But I think there's a tension, a democratic tension, because the state has to be the law if you accept the sort of liberal democratic definition of the rule of law in the democratic state. If the state is going to be subject to the rule of law, how does the state remain the beneficiary or that which is protected by the rule of law?
There's a lot in this again, Faisal, so let me try to unpack. State being about values and symbols, and I said at some point in the talk that, yes, there is this conception of the state as an irreducible agent in terms of propositional irreducibility, that we can pin on the state certain attitudes, certain plans that are not the plans of individuals. They come from them but are not directly theirs, as it were. They're essential to it, but they're not theirs. And so that expression of agency can be held responsible, just like in a way that mimics the way we hold responsible individuals. I also say there might be another model, which is when the criteria for this irreducible agency are not made out, then there might still be good reasons to say that we're holding something called the state criminally responsible for expressive reasons, for reasons, what you call utilitarian reasons, reasons of consequences. That, for example, we punish a bunch of people and we say we're punishing you as the state, even though you're not the state, you're just a bunch of people, such that you organize yourself better, possibly becoming an irreducible agent in the long run, right? So there might be a reason here to say, well, let's punish them. Let's treat these people as a state even though they're not, and punish them as state even though they're not. And so that's a different kind of model, right? These models compete, and when the strong agency model runs out, then it might be that the other one overlaps or complements, but it's a different way of understanding what the state is. Now, the state, with respect to its individuals, there are some societies, liberal democratic societies, in which the citizens of the state will be kind of officials of the state. They will participate. They will have something to do with the state action. They will vote. They will make representation. They'll be listened to. They're in a sense, officials. There are states like North Korea where the people that are in the state that form the structure are just a ruling elite, right? They don't care about the broader mass of citizens. I said they're both states in these cases. But in terms of the depth, who is included in that apparatus, that is different. Now, on the model of strong irreducible agency, it seems to me that the state is not just the law. unfortunately. And even in a liberal democracy, the state is not just the law, right? What do you make of the fact that the Australian Prime Minister apologizes on behalf of Australia for the wrongs that Australia has done to Aboriginal people in Australia? He's not empowered to do so, but people recognize this as something that the Prime Minister can do in the name of Australia. When the British Prime Minister declares war on behalf of the United Kingdom, even though the Constitution is such that the monarch is the one that has that power, well, we still think that he has the power to do so, right? So it seems to me that it's not the same thing, right? So of course there might be norms, legal norms to which we're attached that we deem are important, such as the norms constituting criminal wrongs. But it seems to me that the state that is not the law, yet is a strong agent that is constituted by both legal and non-legal norms, can violate these legal norms and be held potentially accountable for it. Just a little point to conclude. My account is not an account of vicarious responsibility, right? The state is the original planner, is the source of the deed, right? Is the primary, is the cause. Somebody implements that cause. Think of it more potentially as an accomplice or an accessory to the crime, right? That's not vicarious responsibility, right? This is a wrong in and of itself. And this is what the state, where the state crime is involved. And that goes back to the question that Bob asked, saying, well, what is actually the state crime, right? Where and at what point does it become a crime? There is something before the execution, which might be compounded by the execution, just like, the wrong of attempted murder is compounded by the fact that somebody happens to die through my assault, right? So there's this idea of multi-level causation at play, which I think the state as an agent, not just a vicarious wrongdoer. I'm not just saying the state stands in the place of, should be punished or held accountable for the wrongs of others. It's its wrong that I'm trying to get to. Yes.
I've got two questions actually. One is related to Aaron's book. In her book, the guy says that, look, I just had orders.
Yeah.
The individuals. So what about states?
Can the state have orders?
Yeah, my question is that, so the guy would say that I had orders and I just followed the orders.
Yeah.
How about the level of states? This, I think, makes it difficult. The difficulty if they want to know the orders.
So what's the difficulty?
The individual would say that I had orders as a criminal. What about states? They would say that we had orders as well? Because the states are the...
No, but the state, in a sense, is the agent that would put out the order in your case, right? So presumably, there might be other organizations also doing it. It might be, say, the Nazi Party or the SS are doing it.
So
right?
In the case of Nazi Party, for them, they had orders from... Because...
You can go up the chain of causation. It may be that the state directs the government to do something, right? So the whole apparatus, right? The Parliament decides something, it's challenged in the courts interpret it as such, that's what Parliament has to do, that's what the government has to do. That is the government implementing the plan, as it were, of the state, right? Mm-hmm. So yes, within the state there can be various agents, but I say that the whole box, as it were, that comprises executive, legislative, possibly judiciary, all of this, so that structure is the state and may involve citizens also in certain cases. That structure can think things and do things, right? So might other corporate agents, such as the government, such as administrative agencies, such as private corporations within the state. And you also then have individual agents who are always the ultimate enactors, but might take their cue from other agents, such that their responsibility as individual agents can be engaged. Eichmann's responsibility ought to be engaged, but that doesn't mean that he's alone. If you look at the Nuremberg trial, Article 9 of the Nuremberg Charter allowed for the possibility of organizational responsibility. Now, judges didn't want to deal with this. A lot of judges were suspicious of this idea, so it was kind of read out of the Charter. But already the seed of state criminality was present in the Nuremberg Charter.
Mm-hmm. Thank you. And my second question is about I want to know about the argument of the ones who say that states may not be punished. For example, think of the economic sanctions which are being imposed time and again.
Yeah.
So after a time, you would say that, look, this state has worse economic growth because of these economic sanctions. So in a sense, they are punished, aren't they? I don't say that is your view, but you said that there is this view that they say that, okay.
Well, morally speaking, if the state did something wrong and the community, the international community, I'm using this expression loosely, turns around and says, that was wrong, and we're going to make you pay for it.
That's not your view. I want to know the view of the ones who would say that, oh, look, states may not be punished, but they are punished, because when you economically you go back and look at
The question is how you pitch it, right? It could be just trying to incentivize them, and that's not punishment. It's just a way of trying to get states to do certain things. It might just be coercion. You might think of
the
it.
question should be ontological. So, for example, you may say blueness and circularity, how do they exist? Whether they exist or not. Blueness, something is blue, blueness, they're very blue.
The concept of blueness.
Yes.
Right.
How circularity? You would say that then would be ontological questions. No.
So what is the challenge, the ontological challenge here? You're questioning the fact that the state may be an agent, or?
Yeah. So I would say that states as states may be punished because, in a sense, if you don't separate the states from the individuals in a very
Right.
sense, then you would say that, okay, children are dying because of those sanctions and the economic growth decreases. So in a sense, both of them are being punished. Of course, as an entity, you would say that states may not be punished, but the
It may be like, let's think about war, right? You can't really wage war, right? You say, I'm waging war against X country, right? I can't wage war without also intentionally targeting the individual. So there might be cases of mixed punishment, where you're intending to get the state and intending to get the individuals, right? And these cases might bring a set of problems.
Yes, exactly.
So because there might be something that's morally salient about the fact of intending to harm people that is not involved, for example, in cases where it's really what's irreducible about the state that is targeted, right? The policy itself is in a well-tailored way targeted through acts of civil disobedience, through a well-crafted embargo, say, on arms trade, which doesn't really affect the people. It's possible to conceive of this, right? And those are the cases in which I'm focusing, because obviously it might be that war is too undiscerning, right? It will just kill a bunch of people who have nothing to do with what happened. And so as a mode of justified punishment, it should not be countenanced, right? Unless the stakes are so high, the wrong is so grave that possibly.
Thank you.
I think Shin.
Hi, thank you very much, Francois. I've got a couple of questions. I think they might be pedestrian, but first of all, like, why criminal law? I know you teach it and you think it's very important, and it's much more important than sort of the civil remedies.
I actually don't think that. They complement each other. Yes.
But okay. So first of all, just conceptually, when you think about criminal law, you think the right to remain silent, mens rea, those kind of things. I mean, they just don't fit in this context. Secondly, what's the what kind of, and I think this goes to the comments made by the last intervener, what can you get out of the criminal process that you couldn't get out of current processes? So like the non-criminal processes. So presumably, if the state is punished, I mean, you can't hang them, throw them in jail, or deport them. So if you're looking at other remedies, those are also available, and we've seen them in the case of the residential schools, the Japanese Canadians. We've seen those kind of sanctions against state action that did produce results, and it, hopefully had some impact on the people who live there. So that's one thing. Like, what's the advantage given all the disadvantages of the process? My second comment, again,
what are the disadvantages of the process?
No, like, what do you get out of going through the criminal process, given what I just sort of on first glance? I mean, if one goes beyond, the criminal process is the most serious way you can sanction somebody. Beyond that, like, in terms of the actual effect or the punishment or the sanction, what can you get out of the criminal process that you couldn't through the other process? Okay, so that's one question. My second one is I may be having an unsophisticated view of this, but like, corporate law exists to protect individuals who own the corporations from punishment. Okay, so aren't you giving Eichmann the defense that he just couldn't use? Because the and I say this because if the state is responsible, like, let's say in Germany at that time, then either the individuals aren't responsible or they are. If they are responsible, then not only Eichmann, but all the individuals that were involved are responsible, okay? If they're all individually responsible, what do you get out of prosecuting the state apart from prosecuting the individuals? I think that what I understand from your original comment was that there is sort of this sphere of state action that is somehow beyond pinpointing individual responsibility. So an individual could potentially be not responsible for a heinous set of policies, whereas the state would be responsible for a set of heinous responsibility,
Right.
So those are my two.
These are good questions, and I wouldn't want to be associated with the last kind of claims that you make, because I don't think these are the claims that I'm making. The first bit about what do you get out of the criminal process? Well, why go through all this bother of having, the right to remain silent in the company? Well, I'm not saying that in the context of the prosecution of the state, or for corporations for that matter, that either of these corporate entities is entitled to these protection, right? You need to come up with a rationale that says, well, attributing this protection to the state will be valuable for individuals, because only individuals in the last analysis are valuable. So it's not that, like individuals, the state, or the corporation have an intrinsic moral worth that needs to be protected to a right to remain silent, for example. If we're going to have the right to remain silent, and some people make these arguments, Alex Stein, for example, an article in the Harvard Law Review saying the right to remain silent also has an instrumentalist. It is statistically, and he has a complex model that tries to demonstrate through complex gestures that it will be more amenable to the truth, right? So if that's the case, well, to the extent that you're targeting any entity, well, you want to know, did that entity do it or not? That will be essential to the kind of responses that we resort to vis-a-vis that entity. Now you might say, well, don't we do all sorts of things to state in general? Don't we have pretty radical means, wars, rebellion. We have diplomatic means, embargoes, decisions of the United Nations. We already have bills of rights, courts that are intervening to hold the state to certain standards of decency and of dignity for individuals. Do we really need this additional sort of process? It seems to me that in the domestic context, the meaning of criminal law, right? The message that is expressed through criminal condemnation, of calling to account individuals for their wrong, with the potential that they will be publicly condemned, either by the polity or by the world, right, for what they did. In the domestic context, you would think, well, in the liberal polity, you'd think, well, that's the community is actually publicly condemning in a public forum, right? We don't really have other means of doing this. And punishment might be interpreted as serving that purpose, of conveying that message to the individual. Some people might make that kind of argument with respect to domestic criminal law. I think the same applies at the international level, right? The kind of, to the extent that there are legal wrongs that the state commit, and the kind of response, say, calling the state to account. If it doesn't provide a sufficient explanation for what it did, a good justification, possibly an excuse for what it did, then you condemn the state, right? And then there are all sorts of questions about the legitimacy of the body that does this, which I tried to gesture towards it in the talk. But the kind of expression of disavowal, we don't want to have anything to do with this, as expressed through the condemnation and through the response, which may have a consequentialist orientation or purely an expressive orientation. I think that it's something that sometimes we lack, right? Because you may say, well, and that brings me into your other questions, and there are cases where, of course, if a corporation does something bad, you want to look at what the individuals did in that context, and you want to hold them criminally responsible for what they did. But sometimes there are things that the corporation as a whole, right, that Union Carbide did in Bhopal that is not traceable to any individual. If you look at the individuals in the structures, they did bad things along the way, but none of them is responsible for the big thing. You also want to be able to give, for example, the victim or society at large a means of saying that was wrong and Union Carbide did it. right? You want to avoid the kind of shortfall of responsibility that may happen when you're just looking at the individuals individually, right? There might be cases where you're holding everybody responsible for the kinds of wrongs that they did, and you still have that kind of shortfall. Criminal law comes in and by looking at the state, or at the corporation in the case of a private corporation, says, well, there's also this other realm of agency that we're targeting, and we say there was a problem there. That problems need to be changed, and that was bad what happened there. So I think there's a role for this kind of process to be played that we don't really have mechanisms to deal with right now. Yeah. Oh, yes, I don't mean to. Go ahead.
Thank you.
Yeah.
So first of all, thank you. That was, oh, sorry. You can record my thank you too. Thank you. That was really interesting. I have one question that I'm struggling with a bit, and I don't have an answer for. I don't even have an answer in my head for it. So here we go. So I need to ask it to you, so you can give me an answer. So I'm thinking that if we start looking at the state and start trying to find this irreducible quality to the state that's going to enable it to be criminalized, then are there negative consequences for sort of making the state more tangible this way? And I'll tell you what leads me to this question. So when I think about corporations in the States, they've been sort of becoming more and more tangible as time has gone on. So what's the latest piece of that? Now they can give campaign contributions, and lots of people have written about this, and now all of a sudden the campaign contributions are being justified on free speech grounds. But are there negative consequences that if we start to see the state, this irreducible part of the state, separate from the officials, more and more tangibly, then does that mean that actually that could be used in a non-progressive way later? So maybe this irreducible part of the state starts to be able to claim certain rights, or starts to be able to get out of some...
So what I'm trying, and that question works well with Shin's question. What I'm trying to say is that at least in the domestic context, but also in the international context, we don't really have state crimes. There have never been prosecution for state crimes. We've gotten really close in the Bosnia-Herzegovina case in front of the ICJ, but really it's a civil case. It's about compensation. It's not about condemnation, punishment per se. And there are UN agencies that engage in the process of saying, well, states violate human rights, and we're going to tell them that it's bad, but they don't really have the punitive quality that the criminal process would have. What I'm trying to say is that criminal law theorists tend to think of the state as this kind of superior entity that lies above the criminal law, right? It's the kind of entity that, through which the values to which the criminal justice system should give shape are embodied or expressed. It's the kind of instrument for this to unfold. I say, well, through my analysis, now we can deflate that picture and say sometimes it's possible to treat the state as an agent that can operate within a sphere of obligation, an agent that can be responsive to reason, to which we can tell things, such that if it did bad things, it can understand them, take ownership for them, and modify itself, right? So to the extent that that's true and that we can do this, then I want to say, well, why don't we do this, right? We might do it already in other ways, right? So if you look at the law regulating corporations, if you look at what's happening in some states in Australia, you don't really have just a fictional respondeat ad superior kind of model. You have statutes that try to get at what I'm trying to get at, right? The issue of corporate culture giving rise to wrongdoing, right? And this issue of corporate culture says that's where the wrongdoing lies, and we want to be able to get that, and we want to tell that black box under the corporation that it does bad things. We want to condemn it such that it can modify itself. Now you say, well, if you treat the state as an irreducible agent like you do, as a person, to the extent that the person is understood as an agent that can operate within the sphere, a sphere of obligation and respond to it, reasonably, well, can that person invoke rights like any other person? If you go down that road, don't you have to bite the bullet and say, and I say no, right? They might be person in that shallow way that I described, this performative way, but that doesn't mean that their value is the same. So should the state, qua irreducible agent, claim the right to make campaign contributions, the right to vote, then the question to ask is, how is that valuable, all things considered, for people? And you look at the analysis, and presumably given what's happening in the US, the answer will be actually not very, to the extent that it might put more opinions out there in the market, the free market of ideas, then that's pretty limited in terms of helping us to reach the truth. It tends to clog the debate, it undermines democracy. So I'm not saying that the state or corporation should have the same rights. Not at all, right? I don't think you need to go down this route. they might have certain procedural rights that are justified instrumentally because of their value to individuals, but no more than this, right? And I say that many rights that we have in the criminal justice process dealing with individuals are actually already justified in an instrumental way. So the picture might not be that different. It will be different. You can't just look at the criminal process dealing with individuals and extrapolate that process and just say the state or corporation should be dealt this way. In fact, it's a problem for the way we tend to deal with corporations nowadays, or so I tend to think, because we just think of the corporation, well, you know, in our system, it's kind of a fiction and everything, but it's the criminal process, so it has a right to silence, and just because of that, because there are individuals involved. The parliament, the courts don't do that work. And in fact, I'm trying to say, well, theorists needs to do it, and lawyers needs to start engaging in this, because this is happening every day. I tend to think of the state as the quintessential agent, and that goes to Shin's question also. Why do you look at the corporate agent? Why don't you talk to us about corporations, right? You should also do this. The problem with corporation is that they have this profit motive, right? That tend to skew everything they do, right? So you have judgments in the US that say, yes, that's what the primary motive of the corporation is. A liberal state is different, right? It doesn't have this profit motive. If you look at bills of rights or charter of rights, the goals of the state is to basically to govern in a morally justified way, right? That's basically what it is. So in a sense, it has the room to operate like a moral agent. Sometimes it doesn't do it. The corporation, I tend to think as a perpetually mentally disabled kind of agent, right? So the issue might be, well, should you recognize excuses? And that's another kind of issue, right? So I think there are problems with corporations that states may not have, right? Corporations may not also have them. You might say, well, corporations have in their constitution de facto, yes, a profit motive, but at the same time, a really strong obligation to act in a way that further corporate social responsibility and so on and so forth. To the extent that that's conceivable, then maybe we could deal with corporations in the way that I deal with the state. But I had this discussion with Philippe Petit, and I said, why do you use a corporation? And he said, well, because I want to hold them accountable the same way you're talking about holding the state accountable, François. And I said, yes, but your model is, it makes it difficult to do this, right? You can go after the corporations in the fictional ways that I've talked about, but not necessarily in the same kind of real way. Sometimes it might be possible, but they're a different kind of beast. You're the boss.
Well, maybe in the middle.
Thank you. I guess I have another question about consequences. Continuing with your example of the Yugoslavian conflict.
Right.
There's a difference in terms of the social consequences and the consequences for the international system saying that Slobodan Milosevic is a criminal. The Serbians can react to that by saying, yes, we're all victims of him, he pulled the wool over our eyes. But if you say that Serbia is a criminal, that Serbia is a criminal state, one consequence of that could be that Serbians view this as an affront by the international system, as the West ganging upon them, and a consequence is that they're more inclined to elect more radical leaders, and the broader political goal of integrating Serbia back into the international system is impaired. But I'm trying to think whether that's really a question that you need to think about, or whether that's a question of politics, as you say, that really is distinct from what you're trying to deal with, which is whether criminal liability for a state is conceptually possible.
Well, to the extent that the prime justification for punishing the state is at least in part consequentialist, right? That you want to achieve certain reforms through the punishment, right? You want the state to change so that wrongdoing doesn't happen again, and others look at the situation and say, well, given what happened to that state, we, qua states, will not do again. Well, you might say, if that is really what's going to happen, that it might be that needs to be factored into the analysis. Now, I'm trying to steer clear of that by saying, well, depends how Serbia is constituted. First of all, is it constituted in a way that allows for the talk of agency, right, and for the real conception of agency that I'm talking about? If it's a dictatorship and it's really one guy that calls a shot, then it's this one guy. It's not Serbia. Serbia is not an agent that can be held responsible as such, right? So the Nazi state might be different. The Nazi state is such a complex apparatus orchestrated by goals. Yes, there is Hitler, but you may say, well, maybe Serbia fits this model. To the extent that it does, what is Serbia, right? Yeah. The people who are persecuted down the road by the Serbian authorities, and well, are they really Serbia? Right? Are they Serbia? To the extent that these people then, that you have people that contribute to the state wrongdoing, there are people that associate with the Serbia that is the Serbia that we know acting within the conflict, that they're people that actually participate, that they vote, then you may say, well, these kinds of actions by individuals make them more liable to suffer side effects of what condemning and punishing the state might entail, right? Then you might have the discrete and insular minority on the side that just looking at the situation saying we're going to pay. Well, it might be less justifiable to punish the state because it will affect them. But these other people who were really close, they were part and parcel of the state, and they say, well, sometimes it might be permissible to harm them as a side effect of punishing the state. Again, if really it was going to be the conflagration of the Balkans, again, if you do this, then of course you need to think about this, right? So, and in this case, well, the same thing happens in international criminal law all the time, right? At the level of sentencing of individuals, you think, well, what is this going to do? At different stages of the process, should we prosecute X? Should we go and prosecute Harper for possibly knowingly allowing for detainees to be transferred to torture in Afghanistan? Have we heard about that possibility? Well, here at the Nathanson Centre, we've tried to say, yes, we should think about this, but it's just not happening, right? So, and why? Because the prosecutor thinks, well, like Canada's the main supporter of the court. These considerations will be at play, obviously. So obviously there is the question of politics, as I said, that permeates the process. Is there the willpower to develop a system that will be at least, a decent way of carrying out criminal accountability for the state? That's a very tough question. Doesn't mean we shouldn't address that question of at least its theoretical possibility, because I think that starting to think of the state as a wrongdoer can have all sorts of implications for how we think of the state that punishes. What about the state that punishes and commit mistakes and ends up punishing innocents in the domestic context? We tend to think, well, then it has a duty to compensate people. Should we do more to the state? Well, maybe it has a duty to apologize. Should there be more? Right? It's violent. Right? And imagine in the United States, where sometimes the state will kill people for what they did. Oh, it's a mistake, right? How should we react to this? So I want to call for an examination of that kind of behavior by the state through the lens of the criminal law, because I think it's an unexplored lens, and it can yield interesting results that I'm perhaps not yet aware of. But yes.
Just behind you, you have another question.
Thanks, Francois. My question relates to the evolution of the state itself in terms of international history.
The evolution?
Yeah, the evolution of the state. As far as I understand it, the modern Westphalian state formed in 1500s, 1600s. Right. And then you fast forward 400 years, then you have, the decolonization process with the mandate system, which was transferred onto the UN. And, going back to the 15th and 16th century, the formation of the sovereignty doctrine itself, which is tied to a particular relationship between the indigenous and the sovereign, right? And the state itself was part and parcel of that move. So I wonder how do you kind of move into the current understanding of a state without putting that history, and how would your project kind of think about the evolution of the state itself?
Of course the state is an historical phenomenon, right? I do not reject this. The kind of state I'm talking about is the bureaucratic state, modern nation states as we understand it today, right? So to the extent that it meets the condition of agency that Petit is talking about, that's what I'm talking about, right? So you want to say, well, there's something else that we refer to as the state. There are many other things that we could refer to as the state. And you say, well, there's a set of power relations that we want to refer to as the state. Maybe, right? And that goes to the second part of my analysis that I don't take care of here. There might be reasons sometimes to say we're holding the state criminally responsible, not in the way that I'm understanding it, but as power relation. There's value in saying that we're holding the state responsible, even though there is no irreducible agent, right? Because of what was done in the name of this thing called the state, right? We have this power as human beings through words, we put words and we attribute certain functions to certain words, and they do certain work, and they come to have meaning for us, and that's how we understand the way we evolve in society. So there's a big chunk of the argument that will need to address this question, and I'm not denying it, right? When is it justified to impute criminal liability to something called the state, or treat, say, a group of people as the state, when in fact they are not organized as an agent the way I'm talking about. And that's obviously part of the project, the more disaggregated form of the state. And when that's the case, should we just hold the state as having excuses of being, for example, mentally ill or being, subjected to a certain kind of insanity such that it's not an agent and doesn't deserve blame? Or should we say, well, because of the symbolism of the value of just holding this group of people accountable as the state, is that justified, given what we're going to do to these people, right? And the harm that we might impose to them through condemnation and punishment. So yeah.
Well, my question is about the strong irreducible agency,
Yeah.
because I'm still kind of not convinced, you could say. Does it apply always? I know you're talking specifically to liberal, legitimate, elected governments. But for example, if we take the modern Russian state, which is, they have elections and everything, but it's, one could plausibly suggest that it's still pretty much Putin and his aides running the show. So in that case, could you say that there is a strong irreducible agency, or if the state, the Russian state, commits a crime, can we not just say, well, it was Putin and his aides and not the state in general?
Right. But I need to know more about how the Russian state actually operates. Right? If it's just Putin calling all the shots, then presumably it's not Russia, it's Putin, right? Now you can think Russia is a big place, right? It's a complex country. There's a big system that allows Russia to function, right? So there are multi-layered levels of government. What Putin said is translated in all sorts of ways. So what comes out of Russia might be sometimes what Putin says, but some other times it's just this, aggregate, transformed view of what the intention of various individuals are, right? So the question is, well, overall, Petit would say, is it more accurate to describe what's happening in Russia as being Putin, or is it as Russia? Is it the case that we have here a constitutional state that is seeking to act as an agent that corrects itself when it messes up, say doesn't hold firm to its commitments? You could say Russia is a conversible agent. Sometimes it's you would say it's acratic. It has some it's strong-headed. You could so yes, but you could say, well, Russia as a state is, well, Canada can deal with Russia. Sometimes it's not clear, right? You could say that it might be a case where it's teetering on the brink. I don't know enough about Russia. I've never looked at Russia beyond what I read in the paper. But there are cases where you might say, well, okay, Somalia, well, then there is no agent, right? So there are individual agents. There might be small groups of people organized as discrete group agents, but Somalia as a state is not. So that would be the clear case of where, you might have a state, but it's such a disaggregated state that really it's really merely the embryonic form, right? We have a territory and people, and the international society says, well, and we think there's a state here, Somalia, but that's about it. Russia, though, we're much closer to what Petit is talking about. And Petit wants to say, well, if there is that kind of decisional structure in place that allows for the pooling and irreducible formation of propositions and attitudes, such as intentions, and the state has this way of correcting itself vis-a-vis what is done, and when it misfires, it tries to readjust itself so that you can deal with Russia, you can do business with Russia through language, then possibly it is, right? But again, it's a very fluid analysis, and that's why I say I don't want to leave that analysis alone. I want to have this other model of saying, well, when the conditions are not satisfied, are there still reasons to say that Russia is a criminal and ought to be condemned and punished for what it did?
Someone recently recommended that I read John Rawls' Two Concepts of Rules, so I've been giving a fair bit of thought to the difference between punishing in an individual instance and punishing generally. So you mentioned earlier that we might punish a state because generally consequentialist reasons, reform reasons, some impact it might want to have. But to bring it back to the domestic context, because I can only analogize to what I know, if we have an individual that we're trying to punish, we say, well, this would be devastating to his family to punish, and he's much loved in his community. We wouldn't want to do it for the extraneous impacts that, those are the kind of considerations we think normally wouldn't take into account with an individual instance of punishment. When you consider the state and assume for the moment that, there's no political power play here, we are in a position to punish. The question is just what should we do? When it comes to a case of choosing to punish, it actually does seem quite right to say, well, if the impacts of this punishment are sufficiently diffuse that they would affect, the citizenry negatively, that might, incline us to change what we might punish or what we might be first inclined to do. But if we're going to do that, it seems to me we run into a different problem, which is, changing the punishment based on sort of extraneous factors, saying, not sort of having a stable response. Like you brought in the example of maybe you could have a very well-tailored arms embargo as the correct response. But it seems to me at the state level, sometimes you may be able to do that, sometimes you may not be able to do that, and you have to adjust your response accordingly based on who it's going to affect. But if you do that, you run into the problem of not having a consistent response, which is what criminal law seems to dictate. So it seems to me it might be a bit of a dilemma.
Is that what criminal law dictates, right? Typically, when you look at domestic criminal law and the sentencing stage, there's a lot of discretion that's ascribed to judges, right? In the U.S., they have guidelines, but there's no enforced. You might have some maximum and minimum, but in between there's a range. It's also the case in Canada. We have a number of principles that ought to guide judges, and sometimes there are minimum. Now there are more and more minimums because of Harper, and less and less maximums. But to that extent, there's still a lot of discretion on the part of judges. Now you may say, if you look at the factors, it doesn't talk about consequences for others, right? So if I, the state, punish you, Jeremy, and your family will be very upset, we tend to think, well, the overall value of your punishment trumps these detrimental side effects for your family. What if you're the sole breadwinner in your family, and you have many dependents, parents and children, who are, to make the example more interesting, like they have physical impairments, they cannot earn money, and the state is going to put you in prison. Should that consideration matter? In certain states, you have certain pleas that you can enter at the moment saying, well, you need a plea of mercy, compassion here because of the side effects. And sometimes they are received. Perhaps not as much as they should. What if by punishing you, the world is going to come to an end, right? There'll be a grave conflagration because you're held as being this deity. And punishing you is going to have such bad results that some people would say, no, you deserve to be punished, right? But some other people would say, well, actually, there might be other reasons of a consequentialist nature not to punish you. In the context of domestic criminal law, that doesn't always play out the way it does, for example, in the case of war. The imposition of harm in the case of war will typically have colossal side effects, right? So I bombed this munition factory. There are typically many civilians living around. And I bombed many munition factories, and there are many civilians that live around there. And you say, well, in the context of war, suddenly we tend to think of the imposition of harm or the use of violence as being, and its justification as being much more dependent on what side effects are actually at play. Now you want to say, well, when you punish the state, it's not always possible to tailor the punishment such that there are no side effects on individuals, right? The question that the way of thinking about this that I tried to advocate in the paper said, well, let's think about what the side effects are. If the punishment is going to be so indiscriminate, will have so many important side effects, then maybe it's not justified. But some side effects on the side might be permissible at times. And there are reasons to think that, right? You may say, well, the individual is part of the state, they contributed to making the state what it is, they associate with it either voluntary or semi-voluntary, they at least failed sometimes to intervene to stop what's happening. And even if they don't do anything, they're recluse or completely innocent, sometimes they just benefit from having the state there in all sorts of more objective ways, such that they might be not necessarily liable, but it might be permitted to a certain extent to harm them as part of punishing the state. And we think of that, one way in which we think of this in terms of the domestic legal system is we say, well, overall, we punish people and we want to punish the guilty, but sometimes there are mistakes. And these mistakes are side effects of having a practice of punishment which seeks to punish the guilty. And we tend to think that these side effects are acceptable, right? And I would say, well, that's the same kind of reasoning that might happen at the level of punishing the group, punishing the state or the corporation, right? Certain side effects might tilt the balance one way, but some might not.
Thanks. So I was wondering about situations that we might describe often as the executive or some members of the executive hijacking the state for their purposes. In their defense, they might say they didn't get a disproportionate amount of the rewards of their actions to themselves. They might say the state benefited, and they might offer this as some kind of defense of their actions. So even though their position, say as a general president, was enhanced or something by their actions, they could say the country as a whole benefited and offer that, and we would, if they offered that.
That's a different question than the one I'm trying to address, though, because you're asking about their potential criminal liability and punishment, right?
So now I want to ask if your view could make room to see them and the state as co-conspirators, so that there's not a transfer of their autonomy or agency right to the state, that they can act with the state in a criminal enterprise.
Oh yeah, I think that's possible, right? It might often be the case. You're talking about the case of a regime that basically manages to occupy, say, forcefully certain positions in the architecture of the state, right? That allows it to input certain kinds of information in the architecture. If, given this, the state is still an agent, right, because it meets its conditions, and the state, goes along with this, right? So let's say there's still a parliament, there are still courts. They just, they go along with, okay, this leader has just come in and we're going to follow. Musharraf has seized power in Pakistan, but the system is still quite in place. It operates even perhaps better than it used to happen before, which is the kind of case that you seem to be pointing at. But it seems to me that to the extent that that kind of state does things that are wrong, then we might want to think about that accountability just as much as we might want to think about what's the contribution of the military junta and the individuals themselves in that process. Does that make sense to you?
Right, so would you see that then as two distinct situations, like military junta and a state criminal?
To the extent that you have the group agent, right? What is done at that level, then we need to think about this, right? Then you might ask, is the junta organized itself as an irreducible agent? Typically that won't be the case, but it might be. Then could we hold a junta? Just as we might think of the government or the corporation. And then the third question, well, should we think of individuals themselves as wrongdoers? Right? But again, you need always to come back to this, and then if that doesn't work, then are there other kinds of reasons to use that language, right? Which are always in the background. So, yeah. Yeah.
Oh, really? Go ahead.
Sure.
Just be quick, but I'm just curious. We've talked about state and corporate agency.
Right.
Would you be interested in or willing to talk about the judicial system as an agent, or is that just subsumed under the state, or could it be? Could we talk about
the judicial system as opposed to a court, a multi-people court?
Well,
So the Supreme Court as
let's say judicial system. That sounds maybe wider.
Yeah, the judicial system doesn't tend to be organized as an agent. There's a hierarchy, but you tend to think of a judge deciding as is the judge deciding, right? 3 judges deciding together, then you might think, well, are they operating as a group agent? Our system doesn't tend to be organized this way. They render their own opinions. If they all agree together, then it's just a majority, and that's how we think, well, this is the majority judgment, and there might be a dissenter, and we don't care about his or her opinion, right? And so we tend to think of the judiciary or the way it's organized in a state like Canada as basically, people rendering judgments as opposed to group agents. So that tends to be one case of group agents where I'm not sure that it's constituted such as, so as to meet the, you might say, well, it has doctrines such as stare decisis, it's bound by the past. It can do whatever it wants. If a lower court messes up, then a higher court comes in and corrects over time. So you must, there are some arguments to be made there that over time, okay, maybe. But it's hard to pinpoint where the agent is, right? Whether it's the judicial system as a whole or, you know, possibly. You know, I haven't really given thought to this question, but you would think that in certain cases, it might be the case that it's an agent. And in certain systems where the system is really tight and judgments are rather predictable over time, then it is. But yeah, we need to look at a specific judicial system, look at Petit's condition, and then try to ascertain whether they match or not. But
okay, so say take something like the Supreme Court.
Right.
Would you say that the decisions made by the Supreme Court of Canada are completely reducible to the 9 individuals, I guess, who are, say, making this decision, or could there?
It's a tough call, right? Because if you look at the decision-making process, no, right? Yes, it is reducible to them, right? So it's, you know, the majority wins. That's what it is. So it's these guys. But if you look at it diachronically over time, then you may say, well, yes, they decide, but given this constitutional structure they're trying to live by, which is really embodied by the doctrine of stare decisis, which says they can just develop the law in light of certain principles and respecting what happened before. You know, possibly. I tend to think it's a marginal case, but it may be that, yes.
Thanks.
Sorry not to be. I just need to. The state is much more, the state, because of the kinds of balances and checks that it has overall, tends to be a more credible case, it seems to me, because the information comes in one way, it's discussed, there's a vote, it's reviewed, then it's implemented, and people try to exercise discretion on the level of integration within the boundaries that are fixed by the state. So then you could think, well, what is really the state here? Whereas at the level of the Supreme Court, there's much more direct involvement of the individual in a way that is pretty reflective of their direct opinions, which is less constrained by the, and the Supreme Court itself says, you know, stare decisis is not something that they're really bound by, right? If they deem that personally that it's more important to just depart from the law, they will do it, right? So.
We have time for one more question, and I'll ask a question if nobody else is. All right. So just following up on the question that was asked earlier, you said one of the attractions of thinking that the state, as opposed to its officials, can be criminally responsible, is that you get to pin the big thing on the state, and sometimes the big picture will get lost. Could it happen that the big thing is a crime, but none of the smaller things that you pin on individuals are?
I think
so that only the state commits a crime, but because that would be very significant. So the state committed a crime, but none of the individuals.
Right. It could be that what comes out of the.
They were negligent, but they weren't.
Well, if they were negligent, you could say, well, they were negligent not to a point of criminal liability.
Right,
so
right.
They're not
Yeah.
criminally.
They're
not grossly negligent.
negligent.
So, no, I think that's actually like there's Scott Veitch's a book about this, saying yes, that possibility is very much there, right? It might just be that the system really misfires. Everybody did what they could, but because of lack of information that they had, the fear that they were experiencing, the anger that some people had, and simply the kind of relationship between institutions such that there was information that was not communicated, then what results is just terrible. And everybody, you know, nobody really did a bad thing there. They fulfilled their roles within the kind of confine of the roles that they have. The system was just so badly designed that this is what resulted. I think that's a possibility, right? It will be rare, but yes.
There wouldn't be anything like mens rea then. The state.
I think there might.
The state would have a guilty mind, just not any individual. Would that be?
I think that's very possible. Now that's an interesting question. You might say, can the state? And some people always ask that question of Philip. They would say, well, can the state really have an intention without anybody intending X? I think Petit would say yes. Recklessness and negligence are a bit of a different story. You could say the state is negligent here. Like the kind of attitudes were not directed enough, were too inadvertent to the kind of risks that were out there based on the reasonable standard. I think that's actually possible. And that's the reason why he wants to go in this direction. Right? He wants to say shortfall of responsibility is a real possibility. And to the extent that it's there, we need to think about ways of dealing with it. And that might be one.
All right, I think we should thank our speaker.
Thank you very much.